intellectual property has something to do with innovation. So that's my thinking. I don't know if you do actually interact with it on a day-to-day basis. Yeah, because you maybe have to be surround yourself with really amazing people to meet innovations on a day-to-day basis. Yeah.
That's a good response. Anyone else? Anyone can try? Come on, guys. It's IP. Don't be afraid. Don't be afraid. Because once you live here, you need to know how you can use IP. All right?
So I think IP means a unique knowledge or insight that you have that you can convert into a commercial property and thereby making it desirable or usable.
Any other takers? Anyone else back there? Hi. All right. Oh, wow. El Capitan. Here you go.
So, my first interaction with, I'm not sure it was the first, but I don't know if anyone here was actually born when the whole thing with Napster was happening, where people were downloading music and other things like that illegally. And one of the people in my household had a bunch of them downloaded, and I actually got sued. Yeah, and I had to pay a lot of money. So it reminds me of money.
Yes. Oh, hi, Marianne.
For me, it reminds me of, like there are all these things that come out of Kenya, Africa, like, you hear the word Kikoi has been, I don't know, yeah, it wasn't protected in Kenya, or even Hakuna Matata, they're saying it's Kiswahili and then it's owned by someone else. So it's just like, that's what it reminds me of.
Wow. Marianne, you've actually brought out something that I think I should throw out there before I give the definition. A few basic guidelines. Let me have a seat. So, IP is territorial. That's the first nature of it. And Marianne has just mentioned that she had Kikoi had been trademarked in the US. And then the other day we were hearing Muratina has been, the process of making Muratina has been patented somewhere, by Norwegian or something. So that's because it's territorial. What is protected in one jurisdiction cannot be protected if you didn't apply to other jurisdictions. All right? And then there's also the first to file principle. If you're the first to file, you get the rights. All right? As long as you meet the requirements and thresholds. So, IP to me, and I love all your answers by the way, IP to me is simply creations of the mind that can be used for commercial purposes, in a nutshell. So when you say creations of the mind, we are talking about certain inventions in technology, creatives, we're talking about music. If you love Diamond, whatever he does, that's copyright, so it's part of IP. And the definition that I've given out here is that IP can be defined as creative outputs such as inventions, literary and artistic works, designs, symbols, names, and images, which are used in commerce. So when you hear design, symbols, names, images, what comes to mind is trademarks, all right? And moving forward, these particular IPs grant you certain rights. These rights are what we refer to as intellectual property rights. So intellectual property rights can be defined as legal protections because you have to register. So once you register, you get a legal right to use to the exclusion of everyone else. So they protect the creators, inventors, and businesses and enable them to control, exclude, and benefit from the use of their IP through generating income, incentives, and whatnot. An example, I believe we have engineers here. It's going to be whereby you invent something novel, a novel drug, a novel device that can be used to cure or treat something. It could be a procedure, it could be a formula. But because we are doing a medtech devices type of connect, let's restrict ourselves to devices. So you develop this device and you want to, benefit from it and profit from it. What do? You protect it via patents so that no one else can use it for a period of 20 years. So that's one way that you can manifest intellectual property rights. And other ways that you can manifest them are through registration of trademarks, industrial designs, or utility models. All right? So these domains of intellectual property rights, we have trademarks. And what is a trademark? A trademark is a symbol, a sign, a logo, or a combination of both that is used in commerce. Let me have a seat. Yeah. That is used in commerce to distinguish one's business from another. For instance, now you've developed this particular device and you want to be unique, to identify with consumers. You want your consumers to be able to identify that particular product with you or service. You have to have a trademark. You'll give it a unique name, you'll give it a unique design or logo that you'll attach to it. I'm reminded of what we witnessed the other day in Muranga, whereby we saw Benacare going to provide dialysis machines in Muranga. You see, now Benacare is going to be typically tied down with renal treatments, dialysis machines. You hear Benacare, you associate it with renal treatment, dialysis machines, and whatnot. So that's what a trademark does for you. So when you're in business, you need to have that trademark so that you can be able to distinguish your services, products, and businesses from other competitors. All right? Basically, that's what a trademark is. Moving forward, we have patents. I know most of you are here because patents is a very intriguing subject for you. You want to know how you can commercialize and get your patents granted. So patents are rights that are granted to you for your protection of new inventive products. The product has to be novel, that's one. Patents normally have 3 criteria. The product has to be novel. By saying novel, it has to be new, nothing that has been seen under the sun. Secondly, it must have a technical effect or an inventive step. So if it has an inventive step, it simply means that it's non-obvious to the person skilled in that particular field. You have to be able to create something that is non-obvious. It's not generic, it's not common sense, And the third aspect is it must be industrially applicable. Industrial applicability simply means you can manufacture it and produce it in large numbers and also apply in industries. So that's the 3 criteria for patent applications. And then we have utility models. Utility models is what I like to refer to as a small sibling to patents. Utility model basically came about largely because people saw that whatever is being created did not meet the 3 criteria. It's very hard for an inventor to meet the inventive step and the novelty aspect of an invention. So what do? Utility model came up, whereby it only looks at the novelty aspect of your invention. So a utility model is one that will last for 10 years. It only looks at one aspect of criteria, and that is novelty. So once you have a utility model application, it's basically that you're doing small or minor improvements to already existing patents or inventions that are under the sun. So keep that in mind. Utility models are minor or small improvements that are done to existing patents. And sadly, they like to say that utility models are a reserve of Africa because that's when we are coming up right now. But I like to challenge that notion because we can invent something new, something industrial applicably, and also has a technical effect. So don't be restricted. However, it's an option whereby you want to save on costs, you want to save on a lot of R&D, you can opt for utility model application. It gives you the same rights as a patent, and it's also cost efficient. All right? The last one that I have is industrial design. Now, being that you are here to develop medical devices, you don't just go and create and leave it to God to determine it's going to look like. You need to have aesthetics in mind, ornamental appearance in mind. The ergonomics of it have to be factored in. Because at the end of the day, you're producing for the end user who's the consumer. You want your product to sell. You want your product to be in the market and have a distinguished look aesthetically. So what do? You have to come up with something that is ornamentally different and aesthetically pleasing. So that if I walk around and I see it, I'm like, yeah, I want that particular device in my hospital or in my particular, area. So industrial designs are that which protect that appearance of your devices. All right? When you file for a patent, when you file for a trademark, you should also consider industrial designs because that product, the outlook, is something that you want to protect. It's very unique. And just to mention, industrial design, you can see it in cars, Mercedes. They've maintained a certain look for years. All right, BMWs, they have a certain look. It changes, but then there's something which remains constant. All right, in hospitals, can I say the strange? it still remains the same, But at the end of the day, if you want to reap from it, you have to protect it. And how are you going to reap from it? You are going to commercialize your IPRs, of which you'll be able to look at later on in this particular segment. All right? So, having said that, having identified what intellectual property is, what intellectual property rights are, we need to look at how we can register them. And registration is normally twofold, or rather threefold. You can have it nationally, you can have it regionally, or internationally. So in order to be able to have a wide understanding of this, allow me to welcome Nathan Yego. He's from KIPI, that's Kenya Industrial Property Institute, and he's going to take you through registrations. And yeah, my friend, here you go.
Thank you so much. I think there's a slide my colleague is meant to ask.
This one. Before I went there. Thank you. By the way, that's thank you, Diego. I think I skipped. But among the questions that I always like to ask people is, do you consider IP when you're out there pitching? When you're out there talking to venture capitalists, when you want to get investments for your particular invention? Do you consider IP in your budgets? Right now, people online, what do you think? Do you consider it? Elise is saying no. You need to consider it. Maybe someone can answer this. Why do you think you need to consider IP budget in when you're pitching? Anyone? Why do you think you need to consider it? It's money. So why do you need to consider the budget? Like, you have your product, you've come to Wamboi, and you're like, hey, Wamboi, so this is my amazing syringe that I have, I've created it. Or maybe it's a portable sugar measurement scale, I don't know what you call them, hypoglycemic, whatever, measurement tool. And I'm pitching to Wamboi right now. And she asked me about IP. And I say, no, I haven't filed, I don't have an IP. Two questions there. Why do you need to budget for IP? And why do you think it's important for the investor to know if you have a patent application or you filed for IP? Anyone? I'll give you a gift, by the way, if you answer at the end of it all.
Good evening, everyone. So I think it's very important because you're trying to safeguard the idea that you have. So if in case maybe you go to a potential investor, they could easily maybe decide to run with the idea, and then you're just thrown off.
So
yeah.
Investor run with the idea.
Yeah.
So let me just get someone here.
Hi, everyone. Okay, so I think it's important for one to state if they have an IP, especially with investors, because you're quote unquote protecting them from potential lawsuits if they end up investing in your idea and you don't have an IP for it and another company comes in, they might end up paying financial lawsuits and suffering financially. Yeah.
All right, that's true. Any other takers? Abraham, is there any comments online? All right. Yes.
I think it also influences your plans to scale. So if your investor is looking at investing in a product that could scale outside Kenya or outside Africa to other markets, it would be in their interest to know whether you have registered that IP so that they know how far you're able to scale.
Very true, very true. Yes, there's Marianne here.
Oh, I think it also adds to the valuation of the company, as because intellectual property has value to it and can increase the equity of it can increase the investment potential. Yeah.
Very true. Oh, there's a taker there, Lucas, I believe. Just pass it, please.
I think also when you have a patent, it also sort of almost ring fences a market, because you're going to be the only one marketing something unique. So that's revenue, and it shows prosperity, how far it's going to go.
Very true. So all the responses. Oh, one more. up here, please.
Hello, everyone.
Hi.
This Ken. I think it also demonstrates your seriousness. The business.
Yes.
But the fact that you've taken that step to go into IP, then you're really keen and serious.
The commitment is there.
Commitment is there.
Yeah, very true. Yeah. Very true. I hope you can hear me through this one. I think it's a bit low. So all the answers are true, but then most of you have evaded if at all you have a budget for IP. I don't know why that question has not been answered. You've all gone to why an investor would want to know about your status on IP, but about your startup, investing or budgeting for IP, no one has answered that. So in my experience, most startups fail to budget for IP. It's a secondary thought. And that's very dangerous, if I may say, because as you've said here, the responses that you've just given, an investor will ask you, you don't have an IP. How sure are we that this will not be replicated? The main concern is replication of this particular invention. This investor is not going to want to invest in your products if it's not protected. And remember, you protect it through the domains that I've mentioned: patents, trademarks, industrial designs, utility models, okay? So if you don't have any of those, I'm not going to put money where I'm going to lose it. So you should always be able to budget. If you're going to source for funding, include IP. Know the rates that you're going to incur when you're filing, either nationally, regionally, or internationally. How much is it going to cost? How much will it cost to get an IP attorney or lawyer to do it for you? Or even an expert to do it for you, like myself. So once you factor that in, you're going to get the revenue in tandem with your other needs. So when you're moving forward, you'll be able to safeguard and protect your IP, get the funding, get your product into markets without fear of infringement. All right? And before I bring yes?
I have a question on that. So when you budget now for your IP, when you're going to an investor, does this mean that you're budgeting for it, or you've already catered to those costs, or you've already made an application? Because if then the fear is that the product that you're selling to them, there's a potential of replication and all that, and you haven't done it yet, isn't there already a fear that they will have had to put in money for that now to be found out later? So I think the question is, at what point do you cater to that? Yeah.
What's your name? Kathy. Kathy has jumped the gun. She's gone to my confidentiality slide. I'll address that, but just to answer you, you remember the famous Please Call Me case Safaricom had with this inventor guy? The reason that it was so easily taken from him is because he didn't have what we like to call an NDA. All right? I'll just leave it at that. We'll discuss it as we move forward, okay? But one other thing that I'd like to mention, and it goes around in media, in everywhere, when people talk about IP. You need to distinguish. After this, I want you to go out there and say, that's not a trademark, that's a patent, you know? Because someone will say, I want to trademark my invention. I want to patent my trademark. Those are two IPRs that you're just hitting together, okay? I remember reading about Rigiji and his, what was that thing he protected? Rigiji, the phrase Rigiji. And someone wrote in mainstream media that Rigiji has patented, Rigathi Gachagua has patented Rigiji. That is so wrong on so many levels. Because patents deals with processes, all right, devices, and methods, all right? It does not deal with catchphrases, clarions, slogans, combination of names, and whatnot. That is a trademark. So you need to be able to distinguish. Once you leave here, please don't go out there and say things and embarrass yourselves, all right? So allow me now to properly introduce Nathan. Oh, yes? Sorry, going to? Is it on?
But, yeah, I can shout.
All right. Yeah.
So,
Thank you. What's your name? Jane. So Jane, you're also jumping the gun like Kathy here. I like that. It shows that you're keen to see how we're going to go. It's going to be addressed under confidentiality for the second question. And the idea of Muratina, yes, as I said, there are underlying principles under IP. First to file, all right, and territoriality. So just because, for instance, Kikoi was filed as a trademark, and get this very well, okay? Kikoi is filed as a trademark. And it will be very hard for you to file the word Kikoi in Kenya as a trademark. Because, one, it is generic. It is associated with the coastal people. You know, you can't just go and say that you want to have a monopoly over the word Kikoi in Kenya. The same way you want to say Hakuna Matata. You can't protect it in Kenya. However, when you look at the United States, the European side or Western side, that is something new. It's a catchy phrase. You know, it's not something that is generic in their community. So he had every right to file, which he did, and he got it, and he had every right to use it to the exclusion of all others, because simple, it was not generic. All right? Yes. Oh. Okay, so I'm being asked what Muratina is. Okay, this is funny. Muratina is a traditional brew that is predominantly found in the Mount Kenya region of Kenya. All right, so it's just something that is made through fermentation. So this guy went and protected the process, allegedly. I've not confirmed, but that's the story that's going around. That he went and protected the process of making Muratina. So now, if you want to make Muratina, you have to get his consent. If you're in the Americas or in Norway or something, you have to seek his consent. All right? Yes?
Sorry, okay, one last question. So I like that you brought out the fact that somebody in the US, because it's not generic in US, patented the word, you know, Muratina or Kikoi. Oh, sorry, not patented.
Yeah, don't embarrass yourself.
Not patented, sorry. Trademarked, right?
Yes.
Okay, so do you have to be a citizen of the US to apply for IP of now say the word Kikoi in the US? Like, because now you're a Kenyan, in Kenya it's
Yeah.
generic, but can I, who's not a citizen, maybe travel to the US, go there, apply and then come back? Yeah.
You're trying to be sneaky there, but it is possible. It is possible because there are businesses that are established in the US which are originally African or Kenyan, and they have trademarked those particular logos in the US. For you to file outside your country, it is possible. However, there are requirements that will need you to have an agent. Because you're a foreigner, you're not domiciled in that country, you need to have someone file on your behalf, like a representative. So when we, as I said, this is the first series. We're going to have more where we deal with the technicalities of filing, and I'll be able to show you how you file, how you fill the forms. But for this one, you just know that you need to have a representative in that jurisdiction of your interest or designated state. Yeah. All right. Any other questions online? Yes, Abraham?
So there's a question here by Dr. Salsa. How do you ensure the IP infringement by other local manufacturers or masters of manufacturers like Chinese manufacturers?
Well, for that, you need to have a provisional, let's say it's a innovative product, you need to have a provisional patent. And then remember, when we talk about infringement, of which I'll mention later on, but I feel as if people are jumping the gun, you need to understand that if you protect in Kenya, for instance, all right, and Nathan is in Uganda, and he likes to read journals on patents, he likes to, look at all these publications, and he comes across your patent application, because patents reveal information to the public. Once you file, it becomes public information once granted. So I can be able to see from step 1 to 10 of what you've done. And if I have the means, I can reverse engineer based on your guidelines. Because basically you're giving someone guidelines to what you've created. So he's in Uganda and he has my patent document. He reads it. And he's like, yeah, I can use this, It's not in Uganda. He will not get a patent granted, but he will be able to use it. All right? He'll be able to use it. I don't know if that's clear. Because, one, IP is territorial. The reason you're filing in Kenya is because you want to stop the person in Kenya from infringing using the laws of Kenya. In Uganda, it's a different case. All right? He can use it, but he cannot apply for the same patent. All right? And that's why we are told, as Africa, we need to read patent journals, because you might be able to use an invention for free until someone comes and realizes that, oh, he's making money out of my invention, then decides to come and file. But then you cannot file for the same application or same invention. You could tweak it, improve it, file for those improvements, but you cannot file for the backbone of that invention, right? Yeah, so any more questions? So in China's case, just to finish on Salsa's question, in China's case, if you haven't protected it in China and you've pitched to a Chinese investor, they're very notorious, by the way, so you have to go and file in China. And as a business, you always have to factor your area of priorities, market penetration, market needs. Do you want to protect it in Kenya? All right? The other option that you could have is trade secrets. All right? I'm moving in front of my slides. Anyway, it's trade secrets, whereby you say, I'm not going to patent so that whatever I have remains secret. Only a few will know about it. That way, the inventive steps are not public, cannot be replicated. And as Abraham would like to tell me, Coca-Cola is one of those brands or companies that have managed to keep their invention secret for over, is it 60 years or 100 years? For a very long time. Because they didn't patent the process of making the colas, the Fantas, the blackcurrants, the Sprites. They just have a formula which is kept somewhere in a vault. 2 different continents, one in Asia, one in Americas, and no one knows what it is. The people who know that particular secret can never be in the same room at the same time. So those are measures that Coca-Cola employed in order to keep their invention secret. And this is actually important to know that no one can reverse engineer. If you feel that your product or invention can be reverse engineered easily, keep a trade secret. If it's not easy, then file a patent application. All right? Yes.
Yeah. So thinking through that, I think that we need to really have an approach on how to go about it from what you just explained.
Yeah.
Because for instance, if you're looking at innovators here, we are having a regional approach. It's like the solution we are coming up with, we need to have a way of commercializing them. First of all, it would be within the East Africa region, for instance.
Yeah.
So if at all you're able to protect the product here, but because you've not filed a patent in Uganda or Rwanda or Tanzania, just looking at it and it can go outside, the person can really use that and come up with that product and sell in that country. Then how do you ensure the commercialization of your product, considering the innovation?
Yeah.
It also goes further, whereby you realize, like, when you come up with innovation here, you may not have the capability, for instance, to print the boards that are needed. So you do the couple files, you send them to China, these guys print for you what you want and they send them back. So
Yeah.
how do you go about that so as to ensure that what you're doing actually will not be taken by somebody else?
Very
Maybe
true.
we need to look at the approach
Yes.
on how to deal with that, whether it's the Coca-Cola way, we'll see how it is. Otherwise, it's an issue that we need to consider.
Very, very, very true. And I respond? Or? All right. I love that particular comment, because one thing about IP, which I believe my colleague was going to mention, is once you file, let's say you filed in Kenya and your interests are to scale up to Uganda, Tanzania, Rwanda later on, we have something that we call a priority. So if it's a patent application, you have around 12 months before, it's 12 months, right? Yeah, you have 12 months before for you to claim priority. You've made it public, you filed, but then they give you a grace period of 12 months to file in the other states. So if 12 months lapse and you haven't filed, it becomes a challenge that I believe my colleague will be able to explain to you in terms of registrations. But normally that's why we say, always look at your market of interest, priority, so that you can reap revenues through commercialization, and then advance. Because within the first year, if it's a viable product, you're sure to get returns, And once you do get those returns, you're able to meet the costs of filing across maybe Uganda, whatnot, and it becomes easier because now you won't get a patent. You'll get a patent agent to assist you, but then the documentation, you can use what you filed in Kenya to forward it in Uganda. So the costs have reduced there. And allow me to bring Nathan to answer most of these other registration questions as we proceed, guys. I know we'll have a networking session. Whatever is pending in the first half, you can ask me. All right?
Right. Thank you so much. As I've been introduced, my name is Nathan Yego. I'm a registered mechanical engineer, and I work with the Kenya Industrial Property Institute as a senior patent examiner. And I was asked to assist with for the. Sorry. Okay, guys, to our virtual participants, kindly use the Q&A section to ask questions and give comments. At the moment, apologies, the chat section has been disabled at the moment. Thank you. So I'm going to take you through this process. We've seen the various industrial property rights, intellectual property rights. We've seen trademarks, we've seen patents, we've seen utility models, and we have seen industrial designs. And now I'm going to take you through the process of how you can be able to register them in Kenya. And I'll add maybe 1 or 2 comments as I proceed. So that's my designation. So industrial designs. Allow me to take this bottle, kindly. So an industrial design, as Eric has mentioned, is basically how the aesthetics of a product. For instance, this bottle, if you look at it from there without looking at the label, can you tell what's the name of the manufacturer of this brand of water? Dasani, yes. And if I brought a Quencher bottle, is it the same as this? Or if I do Keringet? So you see, the industrial design also serves as a brand. For instance, if you go to the supermarket section and you look at the line of sodas, you cannot mistake a Coke with a Fanta, just basically on the appearance. So allow me to stay with this. I'm going to use it a bit more. So, allow me to zoom in the slide. I actually thought it was a bit bigger. So the first step is what we call filing. Filing is just basically you communicating to us as the institute. We are mandated by law and by the Constitution of Kenya to protect and promote the IP of the people of Kenya. So we are mandated to protect your designs, your intellectual property. So when we say filing, we mean that you bring a form. There's a request, there's a designated form on our website. I'll take you through it. It's on kipi.go.ke. And that form, you just basically tell us, my name is, let me use Eric. My name is Eric, and I want to protect a bottle. Or, because you're medtech, I want to protect a surgical kit. Because you've probably come up with a nice way to package a surgical kit that can help you access the rural health centers. So you tell us what it is you want to protect, and you give us pictures. You give us pictures or drawings or any graphic representation of the article you want to protect, like for instance, if it's the bottle. And I'm sure Eric has asked you to budget for IP. So if you are filing for an industrial design, as of the year of our Lord 2025, the cost for application is 3,000 Kenya shillings. Once you have filed, as an institute, we acknowledge that we have received a request from Eric. You have received a request from Eric. We usually do that within 7 working days. And because by law there are certain things we need to check for instance, have you given us the representations? Because you can tell us, I want to protect a bottle, but you've not given us the image of the bottle. You can say you have not paid. So we usually do that within 7 working days. Then once we have given you an acknowledgement, we do now what we call administrative checks. For instance, I like to say, I know there are probably researchers, when you're submitting, say, a paper to a journal, the journal has a specific format they want you to submit. Or if you're in university and you're doing your final year project, there's a specific way the school you're in, the course you're in wants you to submit. And so in the same way, there's a specific way that you need to be able to submit your applications. So once it passes that stage, we do what is called, sorry, the light is killing the colors of my slide. And I decided to use a flowchart because you're engineers. I know you don't work well with a lot of pros. So the thing that's in the middle is called substantive examination. What do we mean by substantive examination? Eric has mentioned like the criteria for us to register your industrial design, it has to be something that is new. And so what happens is, as the examiner, I will look at your design, and then I will search all available databases so that I can be able to see if there's any design that looks like the one which you are submitting. And should you get a favorable response, we do what is called publishing in our journal. You can, in your free time, you can look at our website, kipi.go.ke. We publish our journal every month, so it should be coming out sometime next week. And then there are also other existing databases like the Global Design Database or Design View, run by different IP offices. And so what this does is we invite comments from the public. Human is to error, right? So there could be something maybe as an examiner I overlooked. But you say, how can Diego give the design to Eric and yet I have a similar registered design? So we give you that period, it's usually 60 days. And should there have not been any opposition, we will give you a certificate. How long is your certificate valid for? When you receive your first certificate, it's valid for 5 years, meaning no one should be able to exploit your design simply because you're the rightful owner of it. You're the the intellectual property belongs to you. And after 5 years, you're invited to renew. I forgot to mention costs. When you publish it, it's another 3,000 Kenya shillings. And then at the end of no opposition, it's 1,000 Kenya shillings to register it. So in total, for you to get an industrial design, bearing no opposition and no formality and administrative errors, it costs you 7,000 shillings, and it's going to be valid for 5 years. So is that a lot of money? Exactly. So we usually have a notion that IP is expensive. I'm here to tell you it is not. And if you have an agent, they'll only pay an extra 1,000 shillings. So that 7,000 shillings will keep you for 5 years. At the end of 5 years, you can renew it for another 5 years. And the renewal fee is 10,000 shillings. And then after that 5 years, you can renew it one more time. So the total life of the industrial design will be 15 years. And what does that mean? After 15 years, your design becomes common general knowledge. What's common general knowledge? It's like the experiments used to do in high school, like making hydrogen, the pipette, you remember that, making water. Anyone can now use that innovation. What does that mean for you as an innovator? It's time for you to keep on improving. That's why you'll find almost every now and then the big brands, for instance, iPhone, Samsung, Apple, they keep on releasing new phones every year. And the new phone usually has a new design, a new way of holding it, and so on and so forth. So that is just basically a brief overview of the industrial design. Then you have, how do we process patents? So the first 3 steps are similar, and that's filing, acknowledgement, and you do the administrative and formality checks, which you call formality examination. Now, so the cost of filing a patent in Kenya, who wants to give it a try except Eric? If you'd guess, how much would it cost to file a patent for a patent? 18,000? 20,000? 100,000? So 50,000. So the institute just requires you to pay 3,000 Kenya shillings to file for a patent. But if you're a foreigner, you pay $150. So is there a reason why you should not be filing for your patent? Okay. So after formality examination, we ask you, please, you look at the report, and you have up to 5 years to request for a substantive examination. That's jargon that I've used. Substantive examination, remember Eric has mentioned, for a patent to be granted, it has to stand on 3 legs: novelty, inventive step, and industrial applicability. So substantive examination is just basically us looking at your application and comparing it with patent literature out there and non-patent literature like scholarly articles, conference proceedings, believe it or not, YouTube, on those applications. And all that is to help us to determine whether or not your invention is, one, novel. Because there's an example, I'm sure Eric has mentioned is going to come to it. There's an example from the European Patent Office where an inventor published the invention on their YouTube channel, and then 3 days later went ahead to file for a patent. And so there's that thing Eric mentioned, priority date. So when the examiner was looking and they said, by the time you're coming to file this invention, someone, that is you, had disclosed it to the public. And so we cannot give you a patent for that. But there are other jurisdictions which give you a grace period of up to, say, 6 months. But like in the European Union, they're strict. There's no grace period. If you've disclosed it somewhere and they happen to come across it, you'll be denied registration. So all that happens with the substantive examination. And that usually, because it's a very vigorous process and you need to be thorough, so our service charter requires us to do it within 18 months, but we try and do it within a year so that you as the applicant are not left hanging. And once, say, we've looked at your application, we'll have to publish it in our journal to let the public know that Project Whisperer has applied for this patent and we have granted it. So it's to let the public know that we intend to give these rights. And that's where now publishing comes. So publication is usually 3,000 Kenya shillings, and we publish patent applications twice. The first time we have to publish by law, and it's common practice, is 18 months from the time you filed. So for instance, if you filed on 1st March 2025, 18 months from 1st March 2025, we have to publish and say, Project Whisperer has applied for patent XYZ. And then after we've done our examination and have deemed it, let's say we've deemed it, it's patentable, we still have to publish it, but that one will not be at a cost to Project Whisperer. So that one. And then after that, after it's been published, it will you now come and pay for grant fees, and grant fee is 3,000 Kenya shillings for residents and $150 for foreign applicants. It's important to mention that patents are like your annual, if for those of you who have cars, you have to pay insurance annually. Or better still, if you have a driver's license, you have to pay a fee every year or every 3 years. So for your patent to remain in force, you have to pay annuities, annual fees, and there's a scale. So usually for the first 6 or so years, it increases by just 500 Kenya shillings. I think it starts at 2,000. I'll have to counter check. And then, the thinking is, we give you these 6 years so that you can be able to fully commercialize. So that by the time you're coming to the 20th year, it will be 50,000 Kenya shillings. But by then you assume you've made your millions, and this is pocket change for you. So allow me to use this slide also to mention utility model. Remember, Eric has mentioned utility model. In other jurisdictions, it's called a petty patent. So it's going to be basically the same flow. However, okay, let me before I proceed with the utility model. How much do you think it costs to file a utility model? 3,000. Yes. 5,000. So the cost, how much? Sorry? Yes, it's 1,000 Kenya shillings to file for utility model. And with utility model, after formality examination, we just invite you to publish. We invite you to publish. Once you've published, we'll go ahead and check whether or not you've documented your invention well, and we will register it. After checking you documented it well, we'll register it and then ask you to pay 3,000 for registration. So it will take you around 7,000 shillings for you to get registration. And the annual fees, you start with 1,500 and it increases, gradually. And you see the lifetime of the utility model is just 10 years. Allow me to, we are about East Africa Health Innovation Series. Why do patents exist? Patents exist to encourage innovation. Let me ask, how many have ever thought about the phone that you have? How many have ever thought about reverse engineering it? Oh, okay. You're medical people. Okay, the X-ray machine. Sorry. I'm using the X-ray machine. How many of you have ever thought about, say, reverse engineering it for your own project? Lisa has, yeah? The Project Whisperer. So, if you get, say, let's say you bought an X-ray machine, the technical documentation that comes, it just basically shows you the major components and how to maintain it and so on and so forth. But from that manual, you cannot know how to produce the X-ray machine, right? And probably it would be like 3 or so pages, or so I'm thinking. However, with patent information, remember we publish, and this is not only a practice that happens in Kenya, it happens world over, and there are several databases, like there is one called eSpaceNet, that's run by the European Patent Office. You have another one called Patent Scope, that's run by the World Intellectual Property Organization. And because there's Google, there's also Google Patents. Now, if you ever, let's talk about the X-ray machine. In order for us to grant you, say, a patent, and this is world over, you need to fully disclose how your innovation has come about. So if you ever thought about an X-ray machine, instead of trying to reverse engineer and coming up with everything from scratch, you can actually just look at a patent database and look for existing patent literature on the same. And you might even get say like General Electric. They've documented their patent in 100 pages. And so there's no way for you to guess. It is there for you. And so one way to encourage innovation is please as you're doing your research, don't stop at Google Scholar, Google, ChatGPT, Gemini. I think there's DeepSeek. Yes, go to the patent databases. You'll find, as an example, maybe you can take out your phones, go to Google Patents, maybe I give you like 2 minutes, Google Patents, and search for, what's maybe I can ask Madam C, what's an example of a medical device? Hey, glucometer, Glucometer. Okay, and type the word glucometer and tell me how many hits you get. Google Patents. Those who are online, you can also participate. 100,000, more than. Is there other types of glucometers? Or it's just one? Yeah, maybe you're thinking of solar-powered glucometer. For rural access, you can search solar-powered glucometer. How many hits do you get? 7,448. And you can see, maybe you can open the first hit and see when was it filed. 2008. Yeah? Okay, so you see, you can be able to get even some of the devices that you probably commonly use. You might find let's say like a water dispenser, you just know there's a water dispenser, but there's probably a whole patent documenting how the dispenser has come about. And this is something that Eric was mentioning, that the likes of China, South Korea have taken advantage of the global patent database to be able to industrialize, because you can minimize your R&D time by, instead of trying to come up with everything from scratch, visit your data, and you see the beauty of that database is it's free. You don't need to pay an access fee so as to be able to access it. So you just look at this information that has been freely given, because there are over 140 million patent documents on all these databases. So with that, let me just, I think the battery is now dead. So now this is my last slide on trademarks. Trademark is just basically your brand. Like for instance, in the room I see Med Device, I don't know, I see Dash. You know, those are I see the gentleman is wearing Calvin Klein. You have HP, you know, that's what the trademark is. That is your definitive brand. And so how to register your trademark? We have an optional, the first step is optional, but we highly encourage you to do it, which is called a search. Basically, when you are with the search, you come and tell us, hey, please check for me if this name exists in the market, in your database. As Eric mentioned, these rights are territorial. And so if you've not registered it in Kenya, if you've not registered it, if it's not registered in Kenya, you can be able to come and register it. And so the other thing with trademarks is there are classifications that have been globally agreed upon. It's named after the city where it was agreed. It's called NICE, or NICE classification. where it divides into goods and services. So there are 45. So, for instance, you have a camera here, I have clothing, I have this Logitech device, I have a watch. These are all fall into different classes. And so, when you are doing your search, like for instance, you need to have probably figured out, what do I want to use this trademark in? But you're a med device, you're in the medical space. So there's a class for, you can either be doing healthcare, so healthcare. So there's going to be a class for that. It's either a good or the service you'll be offering. And when you conduct the search, within 7 working days, you'll be given a report as to whether or not your trademark is registrable in Kenya. As I like to do, how much do you think it is to conduct a search with one singular class? Yes, it's 3,000 shillings. Yes. So once, as I mentioned, search is optional but highly encouraged. Then you go to application. Application, you need to file what is called a TM2. And the cost for applying a trademark in Kenya is 4,000 Kenya shillings. And that is if it's only for one class. For instance, maybe your product is, you want to protect it for, say, the glucometer, but then you also want to protect that no one can print t-shirts with the same. So you do for clothing. For instance, Allah, who famously says those words? Atoli, yes. Atoli registered a trademark and branded it, and it's just for clothing. So you can use it on anything else, but for clothing, it's only Atoli who can exploit it. And even the Gigi, he trademarked it for his clothing, and so you can do it, maybe I can do it on a watch or anything, but he trademarked it for that. So if you're doing one class, it's 4,000 shillings, but if you're adding, it's going to be 3,000 for each subsequent class. Then, if you've done your search, you'll probably have done everything as per the requirements. And so after that, it's going to be easy because the substantive examination had been done. But if not, the trademark examiner will now go through the mark that you have submitted and then take it through as an extensive search. But for them, they'll just search the trademark database in Kenya, because there's no need to go outside Kenya. And that's usually within 30 working days. And as usual, after approval, it's published. The public is invited to oppose or not. And if there's no opposition, it's now registered at so publishing is 3,000 shillings, and I think registration, getting the certificate, is 2,000 shillings. And so you see, it will cost you around 12,000 shillings, and the duration of the protection of the trademark is 10 years. And after 10 years, you can renew it. After another 10 years, you can renew it. It's indefinite. So there are trademarks which are as over hundreds of years old, like Coca-Cola. Yes, and so that is all I have to say about the registration processes. Thank you. So is it expensive? It's expensive, but not as much as you thought. Exactly. Right.
Thank you so much, Nathan. That was a nice presentation, registration. Can I get that one? As an IP expert and one who deals with this, he's just given you statutory costs. So you might want to prepare your patent documents and you come to me and I charge you So you also need to factor those. Don't just think that it's 7,000, 10,000. Yeah, anyway. So moving forward, I would like to go and talk about confidentiality real quick. I know time is not on our side. So what is confidential information and what should be considered confidential? Real quick, yeah? Any takers, anyone online? Kathy? You asked about confidentiality earlier on.
Confidentiality, I think I'd say in general terms, it refers to once you're bound by that like non-disclosure agreement, meaning everything that is discussed from that point is confidential, which means that the agreement will probably lay out some terms of, within the time frame that you cannot disclose that information that is discussed after that, whether it is in terms of approach or costs or timelines, basically any information that is communicated between the parties of that non-disclosure agreement are bound by some terms of reference not to share that confidential information. And I think confidential basically, I'm trying to see how to define it, but it is information that you cannot share with anyone else, and if you do share with anyone else that hasn't been stated in that agreement, there will be some consequences that you will incur. Yeah.
All right, so moving forward, that's a good response. She's mentioned NDAs in the process of answering and all that, but confidentiality basically is what you need to hold in confidence, for lack of a better word. All right, and it is something that as inventors you really need to consider, because you're going out there, you're pitching. What is it that you can say? What can you not say? So you need to be able to know that confidentiality is that information that is not in the public domain, that is restricted to just a few individuals and is held as classified, like you don't want it to leak out there. And it has a certain value attached to it, commercial value. The same example with Coca-Cola, all right? And it normally includes both highly innovative data, example, new designs or processes, or routine details, such as customer addresses. For example, you're a startup dealing with data regarding maybe information of your patients, you're collecting data, and use that information to make or generate revenue. You need to hold that information in confidence, all right? The same way Act in Data Protection wants us to restrict such information from leaking or being misused, is the same way you want to hold that information in confidence. So, as you can see there, there's my friend Rocky and Meow Meow. They just chill, they're talking. And Rocky is trying to tell Meow Meow about this story of how he invented something, and it's in a bar setup, as you can see. Do you think such information being divulged there can be held in confidence? Let's find out. So, if you say that you'll keep a secret, then you must, all right? And this underscores the obligation and responsibility that you have to safeguard sensitive information, often enforced through formal agreements like NDAs. And as Kathy mentioned, NDA will come into play where you want to have a legal backing. In case this person breaches that confidence, a good example is when you go to an advocate. You have client-advocate privilege, right? So if this advocate breaches it, what happens? You have a recourse and you can seek remedies in a court of law, you know? So this is the same thing that an NDA will bring into play. And moving forward, you find that when you discuss, like Rock is discussing with Meow Meow in the bar, you tend to ask yourself, can you just say anything and hold it in confidence? We find that no, you cannot, because one, there's limited disclosure, whereby you won't have it. You know, that limited disclosure, you've mentioned it, someone is sitting there, they over here, they can use that information. So if you want to have something in confidence, you must be able to have limited disclosure, which is key. It has to be on a need-to-know basis. You only share what is essential. Also, you need to have formal agreements, the NDAs and confidentiality clauses, and you need to have restricted access. Not just everyone can come in and access that particular file of your invention, your secrets, you know, how you're making from point A to point B, all right? You need to hold it in confidence. And as Nathan pointed out, you cannot publish that information in public without having safeguards. In Kenya, as he said, it's 6 months. If you publish that information, within 6 months, you need to file for protection to get your IPR. If you fail, then it's public information, all right? So you have to have restricted access, and also you need to avoid the risk of over-disclosure. Rocky must not divulge too much information. You can just tell someone the specific, not even specific, but ambiguous features. Oh, I have a catheter that I want to invent, you know, it's general information. You've not gone to the design details, you've not gone into how its functionality is. You just mentioned it's a catheter. And also, when you reveal too much, you end up losing protection, whereby confidential labels are stripped. You know, you can no longer claim confidentiality because you've revealed too much already. Also, public exposure risk, you need to avoid that. And if you overshare beyond control, exclusivity is lost. This information should be sacred to you. Only you and a few should know it. So you need to be able to have that. And also you need to avoid unintentional leaks when you're divulging this information. Casual conversations can sometimes compromise the competitive advantage that your particular invention has. So what are the best practices that you can have to avoid oh, sorry about that. All right. It's okay. I think it's also this. So what are the best practices that you can employ? One, you need to always have minimal disclosure, as I've said. You need to have training. If you're in a startup or a company, you need to inform your employees that what you can divulge is ABC and what you cannot is CDE, all right? And also you need to have regular updates. That information that you're holding in confidence, you need to keep it updated. Keep and enforce protocols that will ensure no one can access that particular data, all right? The next part that we have is basically on how long confidentiality should last. It's not fixed in any rule, or it's not, basic knowledge or generic, but it depends. But normally, it should last as long as a secret remains undisclosed. In Coca-Cola, it's becoming infinite, because no one has been able to reverse engineer or even try to replicate whatever they have. Pepsi tried, they failed. They ended up coming up with the club sodas and whatnot, but not the actual recipe for Coca-Cola or Coke or Fanta. So, whereby it's properly safeguarded, it can stay indefinitely. Unlike patents, as I mentioned earlier on, patents will last for 20 years. And once the 20 years lapse, then it becomes public information, unless you do something we like to call evergreening. I'll be able to mention evergreening later on. As I've mentioned, this is just a basic introductory session that we're having on IP. But evergreening is something that R&Ds or companies do to extend the life of their patents, all right? So ultimately, the ongoing value of confidential information will depend on consistently having an effective safeguard. It all comes down to you. You need to have safeguards to ensure that information is safe. And Coca-Cola, as I mentioned, they have a policy whereby the two persons who know the formula can never be in the same room. Access to their information is kept highly protected. No one can just walk in and access it. So such measures is something that you should consider having. Now, when we talk about revenue generation through IP, because we've discussed confidentiality, what you can disclose, what not to disclose, You have your product now, you want to generate revenue. What must you do to generate said revenue? Because it's always about show me the money, you know, and the mechanisms that we employ for commercialization, there are several, but the main ones are licensing, we have assignment and franchising. Franchising, let me just mention this real quick. How many love Pizza Inn? You know, it's a terrific, Sam, I do too. So, Pizza Inn is actually owned by, is it Simbisa, a South African company that came up with all this IP. And the IP is in the recipe, just like KFC. It's in the recipe, how they make their chicken, how they make their pizza, how they do all that. And you find that it's a brand in SA, but it's all over East Africa. When you go to other areas, it's there. How did they do that? They commercialized using franchise agreements, whereby they come to someone who has the, space, they have the money, and they enter into an agreement that, okay, we'll give you the recipe, but you need to maintain our standards. That's why if you go to any Pizza Inn in Donholm, Westlands, Buruburu, Jogoo Road, Eastleigh, you'll find they have the same features because that's a standard that had been imposed on these people here by the owners. All right, so that's how they protect the IP, and that information is confidential. A good example, another example that I could give you, KFC, Kentucky Fried Chicken, is the same. Their design is the same everywhere you go, all right? And then we have licensing. Licensing, we have exclusive licensing and non-exclusive licensing. So when you talk about licensing, it comes about where, as an inventor, you've created your invention, but then you don't want to lose it. You want to maintain it and earn royalties. So when you're earning royalties, you license someone who's in a better position either to manufacture, to produce, or to distribute on your behalf. And in turn, they pay you royalties. So these royalties are what will be able to help you, generate the money to pay the annuity fees, as Nathan was mentioning here, because once you get money, we know that you're going to continue research and development into your products. And lastly, we have IP assignment. Assignment is where you relinquish your rights. You sell what you have completely and you give it to another party to handle that IP. So this comes about where you are an inventor, but you're not keen on entering the market. You don't want to do anything with manufacturing, productivity, and all that. So what do? You create the schematics, the prototypes, or maybe just the patent document, you file, and then Eric or Nathan sees it as like, I want it. I approach you and I tell you, can I buy it from you? And you sell it to me maybe for 30,000 or 3 million, depends on how much you want. So that's what assignment is all about. And that leaves your hand, okay? It goes to the other person completely. Now, when you talk about infringement, we mentioned that IP is property. And I like to relate property to IP to land because one, we all want to own land, or some of us already landowners. So what happens when someone comes and encroaches on your land? They've come there, as in this picture, this person built a tent and is just chilling and doing God knows what. This owner has a right to chase him out, has a right to, arrest him and even prosecute him, right? So that is the same principle with intellectual property. IP is your individual property. You've created it, it's intangible, but it's still a property. So no one has a right to come and use it without your consent, without having to ask for your permission or even getting an agreement or a license from you. So you need to authorize, because remember, IP grants you a monopoly. Once that monopoly is granted, it safeguards or runs for a duration, and that duration could be 10 years, 20 years, 5 years. So no one can use that property in that duration, all right? And that's why we find that when you produce something, let's say, let me use a trademark for example. Nike has been counterfeited so many times that I think they're also tired. You have to be able to know that this is a counterfeit from the original. Air Forces, Jordans, all those. And when it comes to medical devices, you're talking about MRI machines that can be counterfeited. And what is the repercussions? This standard is not assured. The brand is not assured. So if you do that to a medical device and you counterfeit or you copy and you don't meet the standards, people will die. So that's why branding, that's why infringement is very dangerous. You need to be able to get proper licenses. You need to be able to get the consent of whoever created that device to allow you to use it, and so that you avoid, hurting people or even selling substandard products. So how do we address and prevent infringement? It's very simple. When you want to address infringement, you need to be able to monitor and look at the market. What is the market doing? There was a good example I'll give you. For example, as Wamboi had mentioned earlier, she was sued for piracy. It was piracy, right? So let me give you an example. A well-established musician, Celine Dion, she's a multi-billion, I think, or platinum performer or songwriter, will not be affected by me in Nairobi River Road selling a song for 5 shillings because she has a lot of money, right? But then if you're a startup and you've copied someone's invention and you're replicating it to my detriment, I'm not getting revenue, I'm not getting money, but you're getting that revenue instead of me. I'm suffering losses. People know you as the manufacturer or as the owner. You see, it becomes a problem because you're infringing on my rights and you're making money out of it. So what happens? All right, I'm going to come and try and stop you. I need to monitor that market. So for us as inventors in the medical field, once you create something, don't just sit on your laps and say, okay, this is done. You need to be able to monitor the market. You need to look at the market and say, this is good, this is bad. Someone is taking my idea, someone's using my invention, they're creating revenue and I'm not. You need to stop them, all right? So you can use IP watch services. You can always explore the journals. As Nathan said, they publish journals every month. So you can use that to your advantage. You can check the databases. You can even employ specific watchdogs like myself, and Medivice here. We can do that for you. We look at for your own interests and benefits. All right. So other preventive measures that you can have is you should always have an updated and clear IP registrations. You should also educate your stakeholders on the importance of IP. Like right now here we have multi-stakeholders. There's KU, there's Invention Education Kenyatta, there's Medivice. How are we going to ensure that whatever we create together does not get infringed? All right. So we need to have that continuous engagement, continuous conversation to make sure that whatever we create is still not being infringed in the market. All right. So the remedies to infringement, that is Black Einstein, by the way. Remedies to infringement, we have cease and desist orders, whereby you simply send a cease and desist order to the infringer. This is normally a polite way of asking someone, like, take down my stuff, all right, stop using my stuff. But then people are always stubborn and complicated. So what happens when they receive the cease and desist but still continue using it? You'll find that the next step will be to go to courts, litigate. You need to litigate in order to enforce your rights. And litigation will come in handy because, one, you've registered these rights, you have a certificate from KIPI. KIPI is a government body, it's well known. So once you go there to court and you're litigating, you say, I filed my patent in 2018. This guy came and is using it in 2022. I still have 20 years, or rather 18 years going, whereby I can, use this particular monopoly. So the courts will be able to look at the merits of the case and determine, hopefully in your favor, unless it's a big company and they pay off the judge, then you're looking at something else, but let's hope it doesn't get to that. Another option that is also good and cost-effective is ADR, whereby you just appoint an arbitrator or a mediator to come and intercede between the two of you. And in doing that, you can come to a compromise. For instance, you can agree to license to this person, all right? And once that happens, it saves on cost and you earn revenue from whatever they made. So it's not always going to court that's a solution. Always explore these other measures that are in place and you'll be able to get the benefits of your invention. So, what do you guys think are the defenses to infringement? Anyone? You've infringed, yes, but what would be a defense? Someone has come to you and told you, hey, you're using my patent, because we are all involved in research right now. Lisa, for example, there, I know for a fact. So you do your research and you infringe on someone's invention. What do you think would be a good defense? I didn't know.
Maybe if it's on. If you say it's life-saving, so why can't I use it if it's going to save lives, perchance?
Wow. Anyone else? I'll come back to you, Lisa. Anyone else?
It's actually the same point, because I was going to ask when you mentioned something about evergreening.
Yeah.
Because in medicine, we have something called non-maleficence, like do no harm to a patient, something like that.
Yes.
So, now I'm asking a question now. So if you have a tool and it's very expensive, yet someone else can make it cheaper and save more lives, is there a bar, especially now that we're in the medical field, to save more lives, as Lisa is saying?
Yeah, there is a bar, because a right imposed on someone is a duty on another person. If I have a right to use this particular product for 20 years, it's your duty not to interfere that right. It's not even an ask, like please don't interfere, it's a duty. And the only way that you can be able to, let's say, circumvent that particular right is in special circumstances, of which Dr. Lucas had asked a question. I think he forwarded a question. A good example is when you talk about compulsory licensing. All right. So when you talk about compulsory licensing, basically you're talking about a government giving you an authority to use an invention that has not, let's say it's dormant, or maybe it's not dormant, but then there's an emergency. And a good example would be the same thing that you asked, ARVs. You have a rise in HIV infections. ARVs are costly, you don't have them. So what do? You're an inventor, or you're a producer or manufacturer. You can reverse engineer, you can produce this particular medication in Kenya. You approach the government and you tell them, like, I'd like to get a compulsory license. They issue that to you, and sadly to the detriment of the patent owner, because they'll issue it to you for free. You'll be able to produce that medication and actually sell in that particular jurisdiction. But the government has to issue that compulsory license. We'll be able to look at compulsory license in our other series of IP. How do you obtain a compulsory license? Circumstances that compulsory licenses will be granted. All right? Now, this question that I've asked here, I want you to ponder on it on your own. Because as inventors, you're going to ask yourself this question many times. Am I infringing on someone else's idea or someone's invention? So once you know what not to do, you'll be able to move forward and create your products with ease and confidence. So I'll leave it to you guys. I'm not going to give you the answer to it. I'll leave it to you, and you'll let me know in our next series. I'll start with this question. All right? Now, I think with that, I've come to the end of my presentation. And I welcome any questions, concerns. Like, guys, the floor is open to you all now. So I'm here, please.
Hi, I have two questions.
Nathan, come join me here, please.
One was on the earlier, you can patent in Kenya and someone in Uganda uses your innovation. Can the Uganda person sell in Kenya?
No, if he comes here, remember you have a legal backing, because you have a certificate of grant from KIPI. So the Ugandan cannot come into the jurisdiction that you're protected in. He can only do it in Uganda, but then once you get wind of it and you decide to file in Uganda, you have a priority claim within 12 months, right? For you to go and file and designate Uganda. So yeah, it's flexible a bit, but you need to have cash money, yeah.
And the second one is still in connection to that question you asked. If you're building something and a part of it is, maybe it's a patented process, say a syringe, the process of pushing it up is probably patented, yeah? Mm-hmm. And then you build a solution that incorporates that. Mm-hmm. Do you need to get a license for that piece of your solution?
You take it?
So patents are for the innovation. So it's not a license for you to, sorry for the feedback. So you find most of the existing patents are building on something else. So we can give you a patent for something that you have improved on, but then the patent is not a license for you to operate at times. So you'd find, and this is common, say for instance, like for now there's this whole burst of artificial intelligence. People are improving day by day. And you can, in your spare time, you can just look at how Microsoft and Google and even Yahoo are paying each other licensing fees. You find probably Microsoft improved something that Google did, but then they cannot exploit it without Google's permission. So you find there's a lot of cross-licensing of the same. Thank you.
Just to add on to what Nathan is saying, a good example is your mobile devices. I know you all wonder, you're talking about IP and monopoly, but then most devices have the same features, the pinch features, the zoom, the cameras, the alignment. It's all about, as he says, cross-licensing. It belongs to someone, but then because you can't hold it, you want to create revenue, you license. So in your case, for instance, if you're doing a project and you feel that there's a chance of infringement or something, it's best to get a license or improve on what they already have and then apply for protection on those improvements. Yeah.
As a follow-up to that, how far does the examination go? For instance, when you looked at the Kukul patent, just looking at that glucometer, you've seen how many there are. So I'm looking at a case whereby you've actually applied it in Kenya, and the person in Uganda has seen what you've done, and they're trying to do it in Uganda, then they decide also to apply the same in Uganda. So by the time you apply, you've noticed that they're doing and you're going there, you realize that they also patented the same in Uganda, but having used your idea. So how far does that search go, so that if this person is trying to do it in Uganda, it comes out that it's already done in Kenya to protect that? I know for our innovators, the market around will really affect, and that's an issue that you can deal with.
So what we do in a day-to-day office is, when you're doing our search, we search everywhere. All existing patent databases. We know you're researchers, you know you go to conferences, we look at conference proceedings, we look at, magazines, scholarly articles. So that's how extensive our searches go. Like for instance, there's a colleague who was looking at, just recently, it was an application from researchers in Masinde Muliro. And he in his search, he ended up finding prior art. And the prior art was a paper that the applicant had published. And that's the same level. And I also need to add that different countries have different rules. So for instance, in Kenya, we examine as to substance. But you find in a jurisdiction like South Africa, once you have probably compiled everything in the format that's required, they call it's registered. And so they leave it to the public to come and oppose it. So in Kenya, it's the opposite. It is us as the examiners. We look at your application and say, okay, this one meets all the criteria. This one, maybe if you change one or two to three things, we invite you to amend so that it gets the criteria, or we outrightly reject it.
And also just to add, the same standards that KIPI has, whereby they do examinations or maybe check prior art, the other national IP offices do the same. So it's very rare for you to find that a Kenyan examiner would find a prior art that a Ugandan will not find. so they're able to check and move forward using that.
We have what is called 2 regional organizations in Africa. So the one which Kenya is party to is called ARIPO, African Regional Intellectual Property Organizations. It is based in Harare, and it has 22 member states, of which Kenya acceded to what is called the Harare Protocol. What this means is, let's say you filed in Kenya, we can forward your application to ARIPO, we call it ARIPO in short, and in ARIPO you designate the countries that you want your patent to be protected. So they'll do the substantive examination at the ARIPO office, and once they have no objections, they'll notify the member states and ask them, so-and-so wants to protect this patent in your country. Do you have any objection? And we either raise an objection or no objection based on our laws. And if you want to go to Francophone Africa, there's an organization called OAPI, and that it caters, it's like a singular office that works for all the parties, the party members in that state. And you'd ask, Africa, why are we doing that? Let me tell you, in Europe, you have the European Patent Office. They do the same thing that ARIPO does. They examine, but then they notify the several member states, and it's the prerogative of each individual country to either accept or object or give no objection based on their laws. Remember, IP is territorial.
And in terms of harmonization of maybe the legal frameworks, we find that there are various protocols that have been passed. For example, in ARIPO, we have the Harare Protocol, you have the Banjul Protocol of Marx, and if you're a signatory, it applies in your country. So most of the laws will be aligned to that protocol, all right?
Sorry, just to add one more, the World Trade Organization, WTO, there's what you call the TRIPS agreement that has meant to allowed many member states to harmonize some of the laws. So you'd find some of the things that are not patentable in Kenya are also not patentable in Europe and not patentable across all the member states. So that's one initiative that has been undertaken. And I think I'm still around, Eric is still around, because I'm seeing we are wrapping up the session. So in case you have any more questions, I'm still around. You can meet over a glass of water.
For those online, I have received your questions. I will do a write-up to answer Nelson, Salsa, and Jemima. Kindly allow us to wrap it up so that we can be able to network, because it is IP and networking. So thank you for your time. We really had an interactive session.
Wow, what an amazing and engaging experience. Did you guys learn anything? Really? Okay, so now we will have a very short presentation by Invention Education, Kenyatta University, by Marianne. So a round of applause for her.
So I'm going to be very brief because we've run out of time. So this was one of the events. This event was sponsored by Kenyatta University, the Invention Education Program, and I'll tell you a little bit about it. So, my name is Marianne Muriuki. I'm the education coordinator for the program. So Invention Education is a mode of learning that we are trying to implement, where we are doing a lot of engagement with the industry and making sure all the curriculums that we teach have a lot of feedback from the industry and not just a very academic program. So the first program that we have in this is it's a master's in biomedical engineering in medical device innovation. As part of the program, biomedical engineering usually has an intersection between medicine and engineering. So this, our program especially then now incorporates the business aspect. So we will, sorry, technical difficulties. So I'll skip the bit about Kenyatta University. You guys are all from Kenya, outside of the guys who are online, so we know about Kenyatta University. So the Medical Device Innovation Program focuses on engineering, medicine, and business. Okay, I'll just proceed without this because some of my slides are missing. So we have a curriculum that touches on some aspects of medicine, where we do maybe clinical immersions where our students go and interact with clinicians. We have aspects on the curriculum that touch on engineering. So we have classes like biomaterials and some engineering classes. And then we have parts of the program that focus on business. And these are classes like business and entrepreneurship, where we will have sections on things to do with IP, business planning. That is in the curriculum part. Then other aspects of the program, we do outreach events like this, where we share knowledge and then also just engage with industry to make sure that whatever we are teaching is a reflection of what the industry actually wants, because we want our students to come out and be very productive in the industry. We have a design studio where our students have access to a prototyping space, and this design studio has design and 3D printing, electronic and signal processing, woodworking, metalworking, and textile and upholstery. So our engineering students at the end of it should be able to be proficient in all of this so that they can be able to prototype and do their projects and innovations within the program. We do offer catalyst grants to innovators and researchers just to encourage innovation. The students go through, have mentors within in the program, both industry and within the faculty, just to hold their hand through the whole process. And then they have to do a mandatory internship. We have industry seminars where we have experts from industry come and speak to them. Likely we'd have one on IP, an event similar to this, but just for the students within the program. We have boot camps, pitch events, and then student exchange program. One thing I did not mention is this program is done in collaboration with Rice University in the US, and we are modeling the masters based off of a similar program that they have, and we are currently sponsored by the Lemelson Foundation. So if you want to know more about the program, I would invite you to connect with us as a potential student. There's a QR code there that will give us your information, and we'll be able to share with you events about the program. If you want to engage with us as a guest speaker, a project mentor, you can use this QR code as well, and we'll get your information and reach out to you. And I think I am done. I'll hand it over to the MC.
Thank you, Marianne. So I think I'll give you guys about 1 minute to just scan the QR code and yeah. Okay, thank you so much for attending. Ideally, that marks the end of today's event. I'd like to thank everyone, starting with Marianne through Invention Education Kenyatta University for sponsoring the event. In addition to that, I'd like to thank East African Buyer Design. That's why we have the entire hybrid session. Amazing, thank you so much. I'd also like to thank Nairobi Garage for giving us this space. It is very nice. Oh, it is very nice, it's very beautiful, so thank you so much. And most importantly, I'd like to thank each and every one of you for creating the time, especially on a Friday. So thank you so much for coming. As you heard, this is a series that we want to have, so we'll be having more of these events. Now, Abraham, can you scroll to the next QR code? It's okay, so I think from here we can just gather in front to take a very quick photo. After that, we will have a QR code where we'd want to know how we did, and so that we can just improve. So if everyone can just move forward for a very quick photo.